Well, good afternoon. On behalf of Fawn Construction, Eric Crawford, who relatively new members to ASA. Eric is Director of Sales for North America for Fawn. So we're pleased that they're sponsoring the Contract Education Series. Today's session is The Sword and the Shield, Understanding the Colorado Contractor Trust Fund and Mechanics Lien Statutes. It's my pleasure to introduce Danielle Maya, Esquire. Danielle is a founding partner at Galvanized Law with a 20-year plus track record for outstanding service and advocacy to construction clients. Her practice encompasses all areas of construction law, including construction defect litigation, lien law, bond law, building code violation defense, OSHA defense, construction license issues, and contract review and drafting. Gosh, Danielle, I think I know what you're doing during your daytime hours. Ms. Maya is licensed in Colorado, Texas, Oregon, and Arkansas. With that, Danielle, it's all yours.
Well, thank you so much, Deb. Really appreciate the opportunity to speak to the folks at Substrong and appreciate the sponsorship by Fawn. And it looks like at least we've got two people here. So welcome, Mark. Welcome, Cassandra. And I'm going to just say a warm howdy on a snowy day. If you're wondering, I've spent a good deal of time in Texas, so I don't know if you'll hear that accent come through, but the more comfortable I get with this presentation and with you, probably the more the accent will start coming out. So welcome to my home office. We also have an office over at Tradecraft, and if you haven't been there, it's a great place to kind of do an office share situation. But what I'm talking to you today about is the Sword and the Shield, understanding the Colorado Contractor Trust Fund and Mechanics Lien Statutes. So they always say it's not a problem until it's a problem, right? But how do you know there's a problem? You have to identify something first to fix it. And I think that there's a lot of contractors out there that don't really understand the trust fund statute. So I'm going to focus most of my time today on that, and then we'll talk a little bit about mechanics liens. But basically, there is always so much that you can do to protect yourself from legal issues. However, if you want to be proactive and have a little or reactive help, we're always here to help. But my goal for you today and always for my clients is to have you spend as little time and money possible dealing with legal issues, because that's not what brings you business. So the most important thing for you is to try to get everything streamlined so that you don't have to spend a lot of time talking to me or a lot of time chasing your money or dealing with lawsuits. So as Deb mentioned, our firm is Galvanized. We proudly started Galvanized in this pandemic. Started it in July of 2020. I, along with two other female partners, Kate Strauss and January Allen, started Galvanized, and we were 4 lawyers at the time. We're now up to 8, and we are licensed in 5 different states. I am licensed in 4 of those states, but Wyoming is the other state that we're licensed in. And we are just serving the construction industry. That's our primary focus. So the Sword and Shield, and the reason I titled my program this way is because the trust fund can help you, but it can also hurt you. And I know a lot of folks are subcontractors, right? That's why they're members of ASA, or you're attending this is because you're subcontractors. There are some general contractors here, but a lot of times people think that the trust fund really just helps subcontractors, and that's not necessarily true. It can help you and it can hurt you. If you don't pay as a subcontractor, if you don't pay the folks timely and downstream, then it can also hurt you. So what's the purpose of the trust fund? First off, it's to protect property owners, subcontractors, laborers from dishonest, and suppliers, of course, from dishonest contractors. And, Colorado has a really long, rich history with this statute. They enacted it all the way back in 1975. And I can tell you, because I practice in 4 other states, that Colorado is by far the toughest state that I've seen so far in terms of the teeth that it puts in for the trust fund violations. Now, flipping that, I don't know if you've heard me talk before, I've said that I don't think that Colorado is as friendly to contractors as some other states. And one of the reasons I don't think it's as friendly is because on your straight up breach of contract claims, you don't get attorney's fees unless you have an attorney's fee provision in your contract. On your mechanics lien statute in Colorado, you don't get attorney's fees. And, why is it such a big deal about getting attorney's fees? Well, it's not just because, I want to get paid or I want the other side to pay my bills, which I do, but it's because, if you've got a $20,000 dispute, are you really going to pay me $50,000 to take it all the way through a trial if you're not guaranteed of getting any attorney's fees back? Most often the answer is absolutely not, but some people on principle just want to fight it. So anyway, conversely, the Colorado legislature and Colorado as a state really protects contractors and subcontractors and material suppliers very nicely with this trust fund statute. And the purpose behind it really was to make sure that dishonest general contractors, especially general contractors coming in from out of state, taking the money and leaving, that there's some pretty stiff penalties for that. But it can also bite you as a subcontractor if you don't pay people downstream. It is also to protect property owners from paying twice, which is a good thing. We don't want to have our property owners have to pay twice. Although the purpose of our presentation today and the support that we give, we don't generally represent property owners. So, that's nice, but that's not really the goal here. So what is the trust fund? The trust fund statute requires, quite simply, contractors or subcontractors to hold funds in trust for the payment of all subcontractors, material suppliers, or laborers. This creates an actual fiduciary relationship where you are required to hold those funds in trust. The funds that you are supposed to hold in trust are those that are for furnished labor and materials or services, that any funds that have or may have a lien against the property, so anything that somebody could file a mechanics lien on, any funds that there could be a claim made against the principal or the surety that posted the bond. Now, the Colorado trust fund statute is buried in the mechanics lien statute. You might want to take this down, and if not, you can always hit me up afterwards and I can give it to you, but it's CRS 3822-127. Why is that important? You'll see a little bit later in the presentation. One of the things you can do to help yourself is you can demand an accounting when you think that there could be a violation of the trust fund statute, and you might want to cite to it specifically, saying, I'm demanding an accounting pursuant to CRS 3822-127. Hopefully that'll get somebody's attention, but if not, we're always there to help. So here's the big kicker. This is why Colorado has put huge teeth. I'm talking lion-sized teeth, or think of Jaws coming after you, right? So Colorado has put some serious teeth into the penalties of violating the statute. So if you violate this, they actually said in the statute that you commit theft as defined in the criminal statutes. Now, if that doesn't stop you in your tracks, I don't know what will. I hope after this presentation, I motivate you to make some changes in kind of your processes and procedures. I hope I don't motivate you to head off to Costco and get a month's supply of Depends, because that's not what I really want to do here. But yes, there's criminal potential here, and it's pretty severe. So what creates the trust? It's pretty simple. It's a contractor or a subcontractor. So any one of those two who actually receive funds under a construction contract or a construction project. So you don't have to have a construction contract If you're just doing construction work and you've got a verbal agreement, yeah, it still applies. So watch out. So what does it really mean? It means that contractors can't use any funds for any other purpose until all existing and potential claims have been satisfied. So if you received funds for Project X, they need to get paid out immediately to subcontractors and material suppliers for that project. You cannot pay overhead expenses until all subcontractors and material suppliers have been paid. You cannot pay Project Y bills until you pay everybody on Project X. And here's where it gets a little bit interesting, because I think most everyone, I guess I'll just kind of throw the question out there. Is there anyone here? And if there is, hit me up on the chat. But is there anyone here today listening that gets paid money on a project and doesn't put it into your operating account? I think pretty much everybody does that, and that's the standard procedure. But if you put it into your operating account and you end up paying some other bills in between, it's questionable whether you have a trust fund violation. If you end up paying everyone downstream pretty quickly, hopefully nobody will ever complain, but they could if later in the project you get a little bit off track. So, for example, we, out of our operating account, we have our legal research bill that gets taken out, and I think it's $1,500 every single month, and they tie it right to our bank account. We couldn't set it up any other way. We don't get an option on paying on that. And I don't know if you guys have any other bills that just kind of pull right out of your operating account, whether you okay them or not. But you might want to watch out for that, because the timing is really critical here. So here's kind of the key thing to remember, is that liability attaches when you as a contractor receive funds in trust, but then redirect them to another purpose. And my example just a little bit earlier about paying Project Y bills until you pay everybody on Project X. Well, I'm assuming that maybe you got behind on Project Y, that Project Y actually came before Project X. I should have probably rearranged that in my hypothetical. But if you actually pay, if you're late on Project Y and you kind of get off track on Project Y, don't pay your last invoices first. Come current and and take each project, make it stand on its own. So here's things that you absolutely have to do. So the first thing is that you have to account for each project separately. And if you don't have an accounting system similar to QuickBooks, if you're not doing that internally, if you're doing it externally, I've had clients that, have all their books done externally with an accountant, but the accountant was putting everything into the same account. So there weren't separate accounts for each project. You really, even from a business perspective, it's a great idea to have separate accounts for each project, even the small projects, so that you know what you're really making on it. But you have to do that. If you have material suppliers, you have to keep, so even if you're not employing subcontractors downstream for you, if you just have materials for a specific job, and I'm assuming that your material suppliers are material suppliers that you use on multiple jobs, right? But it is job specific, because your material suppliers, if you don't pay them timely, could make a trust fund claim against you, and they could demand an accounting from you. And so you need to be able to, with a few clicks of the mouse, print up for them and produce to them a project accounting. And I haven't done it personally, so I don't really know what it's like. I don't have to keep separate project accounting in my business. I do have to, obviously, for each client, but I don't have to do that on a construction project. But I do have clients that are doing that, and it seems pretty straightforward and simple. So at a minimum, if you do nothing else today, if you're just throwing your money all into one account, you need to make sure that there's a QuickBooks type thing that separates that for you. So the timing is key. We touched on that a little bit earlier, but here's how the timing could trip you up. And This is something that I've seen recently, and the trust fund claim wasn't really something because the project hadn't really started, and so the contractor hadn't started paying folks downstream yet. But here's the hypothetical. Let's say, for example, on January 1st, you receive an application, you actually submit a payment application for $115,000 for work that you've done on the Smith house, and you submit this to a GC to get paid. In that payment application, there's $50,000 for a roofing subcontractor, and there's also $50,000 for roofing materials. In it, you also have $15,000 for your profit and overhead. Now we're going to assume that on January 16, you are paid $103,500, which is less your 10% retainage that you apparently agreed to on the Smith project. And you put all of that $103,500 into your operating account. If on the 17th, the next day, you have a payroll for your staff of $30,000 and you pay that, we also assume that on the 18th, you pay the supplier for the Jones house, a different project, $50,000. And then on the 19th, you get around to paying for the roofing crew on the Smith house and also the roofing materials. Do you have a trust fund violation? Yes, you do have a trust fund violation because you didn't pay out what you got on the Smith house. And especially this would hit if your balance dipped under the $100,000 mark, because the $100,000 mark was the amount that you were supposed to pay these roofing crews. So if you got other money in the interim, if you got another $50,000 in to bring your balance up to $100,000 so you could pay your roofing crew on the Smith house and your roofing materials on the Smith house, you still violated the trust fund, but no harm, no foul, right? Because if you finally pay them, they're probably not going to make a trust fund claim against you. However, if later on in the project things get off course, they could have a pretty decent argument that yes, you did violate the trust fund, and that would not be good for you. So accurate and precise record keeping, that kind of goes hand in hand with accounting for each project separately. Make sure that you are real clear about that. Establish the systems for payments, so when payments come in and when payments go out on a project. And then the very last one is a separate bank account is not required, but it is a best practice. So in preparing for this presentation, I reached out to a couple of accountants and a couple of bankers, and I said, have you seen any folks in the construction world do separate accounts where they kind of have a trust account? And in Texas, they require it for every single project. So every single project has to have its own separate bank account. That is not required here, and that seems a bit onerous. But if you did have a separate account where you put all project money and that you didn't take any of that money out of the account for your profit, for your overhead until the job was actually over and you really earned it, it would keep it a lot cleaner. It wouldn't prevent, if you only had one account for all your projects, right? It wouldn't prevent you paying project X before project Y, but it really could streamline things up for you and prevent. So if you get into litigation on this, I guarantee you they're going to ask you for your bank account records. They're not going to just ask you for your QuickBook reports, because they want to see if the QuickBook reports and bank account records actually match up, and make sure that the QuickBook isn't, created out of thin air, that it's not a fabrication, which they're entitled to. We always push back pretty hard and redact other things that are in there and just keep it to the project specific stuff. But if they really push on it, and especially if there looks like there's a trust fund violation, they can get everything. And so they can see all of your charges during the period of time that this project was going on. And you don't want them to see. This gets you in trust fund violation too, is paying your children's pediatrician out of your operating account. Having parties, buying alcohol, that kind of stuff. That can be a legitimate business expense. And anyone who runs a business understands that, you want to have staff parties and you need to take clients out. but they don't really understand why you need to pay the medical bills of anyone that's an owner of the business. So be careful about that. So penalties for the trust fund violation. We've touched on this just a little bit, but they're super stiff, and this is where the teeth really come out in Colorado. The criminal liability for theft, we talked about that. There's also personal liability. Yeah, personal liability. So not just your company, but individuals in the company. We'll talk about that more in a second. Treble damages. So if your trust fund violation was $20,000, if that's the amount that you failed to pay your subcontractor, they get to multiply that times 3. It's now $60,000. If they can prove what they need to get to treble damages, and we'll get to that. They also can get attorney's fees. Bankruptcy cannot fix it, and they get interest. So that's an overview of all of the bad things that can happen to you if you violate the Construction Trust Fund Act. Let's talk about the criminal liability just for a second. So it's not as common that people will pursue this on a criminal level, but they can. And if they wanted to pursue it on a criminal level, they would have to convince a district attorney to take their case and pursue it against you. And the likelihood of district attorneys taking those types of cases, especially now with COVID, I think is a little less, because right now they're having a hard time doing jury trials for people who have actually done non-money crimes, so drug crimes or actually injuring somebody. So those are the people that they're still trying to get trials on, jury trials set, because there's a Speedy Trial Act. And so the criminal system is a little bogged down right now because they can't physically put jurors in the seats as easily as they used to be able to do because of COVID. So anyway, so hopefully you will not engage in any liability because you think, I won't really get a criminal complaint. But you cannot fix the trust fund violation by paying it back. So if you shorted somebody $20,000 on the project and you actually use that money for some other purpose, if you went and bought a new, it wouldn't be a very expensive truck, but bought a new piece of equipment for $20,000 and then got around a year later and said, oh yeah, I finally have some money and I can pay this subcontractor. You can't fix it by paying it back. Once you've violated the trust fund, you've violated the trust fund. So don't do it. Here's what the criminal liability looks like. If you've never looked at sentencing guidelines, this is what they look like. So for a $20,000 violation, that's right there, it's a class 4 felony. And a class 4 felony is anything between $20,000 and $99,000. And this is a minimum sentence guideline. It can get you 2 years of hard time and or a fine of $2,000 or a maximum of 6 years and a fine of $500,000. So this is really, really bad stuff. The good news is that criminal theft requires something more. So when the trust fund statute was created, just on its face, it really says that if you fail to hold money in trust, that it subjects you to criminal theft. But thankfully, even though the legislature didn't really get it right and do a very good job of writing the statute, in my opinion, the courts have looked into that and said, no, what they really meant to say was you still need to have the intent factor, because to be liable of anything criminally, you have to prove intent. That's a key thing. That's what they teach us in criminal law. It's been a while since I've been in law school and had to deal with that, but that's the big issue with criminal law, is that there's the element of intent. So getting to the element of intent, what they have to prove is that you knowingly obtained, retained, or exercised control of a thing that belonged to another. You intended to permanently deprive them of that thing. The standard of proof is beyond a reasonable doubt. Why does that matter? Well, in a civil trial, when you're not in a criminal trial and you don't have criminal charges against you, the standard of proof is a preponderance of the evidence. And what that means is just a little bit more than 50%. If you can see my hands, just if you can tip those scales, it's just a little bit more than 50%. But beyond a reasonable doubt, there is absolutely no question. It's pretty much 99%. They're absolutely sure that you committed criminal theft in this case. And then also, it has to be a unanimous verdict if it's a criminal charge in a criminal trial. So those are all great protections for you if you get there. Hopefully you don't. I mentioned the personal liability. Now, who is personally liable and how are they personally liable? Pretty much anybody that touches the money or controls the finances. So here it's control of the finances. It can be officers, owners, vice presidents, managers. How are they going to know? How are they going to know who really controls the money? So if you go and do your research at the Secretary of State's office and you pull up articles of incorporation, sometimes it lists an officer, sometimes it doesn't. So typically they're not going to know this unless you're giving them some reason through the course of dealing with them in the project about that information. One way that they're going to know it is who's signing off on those payment applications, who's sending the emails when they don't pay. Those people really stand a high risk of getting sued. Absolutely, all owners, officers stand a big risk of getting sued personally. And the corporate shield does not protect you here. Your company does not protect you. If you had control or could have controlled the finances, you can get sued and you can go down hard for this. So the personal liability includes the liability for the civil theft, for the treble damages, and for the attorney's fees. It's not just the $20,000 that you failed to pass on to that subcontractor or the material supplier. So this is stiff stuff. So how do they actually get to treble damages and attorney's fees? Those are punitive damages. It's what we consider punitive damages. And so something has to be proved that's pretty significant. Fortunately, Colorado case law, the judges in Colorado have decided that just a mere showing of a violation of the Trust Fund Act, that you didn't hold money in trust, is not sufficient to establish that a crime of theft has been committed and that it won't allow you to get to treble damages and attorney's fees. So you have to prove each of those essential elements of theft, the knowing violation, beyond a reasonable doubt, in order to be convicted of the theft part of it and to get to treble damages and attorney's fees, because the treble damages and attorney's fees are remedies that are in the criminal statute. They are not in the civil statute. They're not in the mechanics lien statute. They're not in the trust fund statute. So one court summed it up this way: if the contractor was aware that his manner of using trust funds was practically certain to result in depriving a subcontractor or supplier of his funds. So that's kind of the test that the courts have been given. I mentioned earlier, the bankruptcy can't cure this. So if you have a trust fund violation, trust fund claim violation, even if you didn't get to the treble damages, if they weren't able to prove intent, if they weren't able to prove a knowing violation, just the trust fund claim alone, that $20,000 amount that I talked about earlier, it is non-dischargeable in bankruptcy, which means you come out of bankruptcy and you still own that. And so if you declare bankruptcy for your company, if you declare bankruptcy individually, you can't discharge that. And if the tribal damages get applied to you, and if attorney's fees get applied to you, you can't get rid of that in bankruptcy either. This is kind of a more recent change in the bankruptcy code, but the bankruptcy code was amended by the good folks in Washington, the legislature in Washington, not in Colorado, to protect consumers. And they made the decision and enacted a statute to say that debts are non-dischargeable if they are debts for theft, if they are debts that are obtained out of fraud or defalcation while acting in a fiduciary capacity. Well, there's a mouthful, right? So what is defalcation while acting in a fiduciary capacity? Well, unfortunately, that is a trust fund violation. And the courts more recently have ruled here in Colorado out of the 10th Circuit, well, not, I guess, the appellate court, that in this context, it means that you failed to properly account for the funds. So just getting a letter from the other side saying, can you produce an accounting pursuant to the Colorado statute? If you can't, then, and you don't, then you're in the defalcation land. And so that means that you can't discharge the debt. Unfortunately, defalcation doesn't require any deliberate wrongdoing. It doesn't require any element of intent or bad faith. Just being negligent. Just being negligent will get you there. So having poor accounting gets you to defalcation, which means you can't discharge this type of a judgment in bankruptcy. They're also entitled to interest. So what interest are they entitled to? Are they entitled to the contract rate? Hopefully you didn't contract for a rate of 24% or 20% or 18% on unpaid amounts. Are they entitled to the mechanics lien rate since it's in the mechanics lien statute of 12%? Or are they entitled to the Colorado statutory rate, which is 8%? The answer is 8%. So fortunately, it's a little bit lower. That's a good thing. So if you're a subcontractor or a material supplier, how do you prove a trust fund violation? Well, if you haven't been paid on a project, the first thing you want to do, so we're going to talk about a couple of things here, and I'm going to bring in the contract piece of it, but Colorado, another thing, I don't think I mentioned this earlier, but another thing that Colorado is not so kind about is pay when paid and pay if paid. And hopefully you guys know the difference, but pay if paid means if the general contractor doesn't get paid, you're never going to get paid. So you basically, if you've signed a pay if paid contract, you basically said, I'm going to do some charity work for the property owner. Because if they don't want to pay you, you really have no recourse, kind of, except for the mechanics lien and the trust fund statute. So those trump even if you've made a huge mistake and signed a contract that said you only get paid if the general contractor gets paid. So pay when paid is a little bit different. And if you are just dying to do work for this general contractor and they're saying you have to do it with this pay if paid clause, you really need to negotiate that to pay when paid and get that changed to pay when paid, because pay when paid gives you some protection, because it means even if the general contractor doesn't get paid within some reasonable amount of time, and that's up for debate with the courts, you will get paid. It doesn't mean that the general contractor can never pay you. So please don't ever sign a pay if paid, but just know if you do, you have the protection of the mechanics lien statute. So the first thing you want to do is make sure that you've protected your mechanics liens, and we'll get to that in just a second. But then the second thing you want to do, if you think that the general contractor has received money and hasn't been paying you, is you want to make a demand for an accounting. So send that letter, whether you have an attorney send it for you, which sometimes can carry a little bit more weight and terrify people a little bit more, I don't know why people would be so afraid of me, but anyway, or you can send it yourself. So, you know, say, dear Mr. ABC General Contractor, I am hereby demanding an accounting for the Jones project pursuant to Colorado Revised Civil Statute 3822-127. That's about all you have to say. And they need to then produce an accounting for you. And if they don't, then you've set them up for not being able to discharge this debt if they end up declaring bankruptcy. So what you would have to prove in a lawsuit is pretty simple, is that you have an unpaid claim and that a general contractor or a contractor received trust fund payments, which is money meant for subcontractors, laborers, or material suppliers. That's all you have to prove. So if you're on the flip side of it, and this is where the sword and the shield kind of come into place, right? So the shield is a protection. So the trust fund statute can be a great protection for you, but it can also gouge you, and I don't want you to get gouged by it. So if you receive a letter to produce an accounting, you need to do that. But it's really critical here to probably get a lawyer involved at this point, because you want to be careful what you produce. I've got a different example. Fortunately, I don't have any examples of clients producing accountings without clearing it with me first. But I do have an example of a client wanting to respond to an OSHA investigation. And in the OSHA investigation, they kind of got me on board a little bit later, and they were like, yeah, they asked for this information. We're just going to dump it all on them. You know, we've got all these pictures from the project. One of the citations that they got in the OSHA citation was for not tying off on a roof. And so, you know, we were looking at it. But one of the pictures that they were wanting to send over was a picture of a guy that was down on the ground looking up at the roof, where they were throwing materials off and doing a lot of ripping off of things. And he didn't have a hard hat on. And, you know, there's another OSHA violation. And so I kindly said, well, you know, we don't have to show that guy standing there. We can kind of cut that guy out of that picture. There's nothing that requires that we incriminate ourselves. So it's always a good idea to have an attorney kind of look at things before you push them out the door in responding to an accounting. And you want to show here that all the payments received for Project X were first used to pay all subs, all material suppliers, and all laborers on Project X. The timing is absolutely critical here, and showing payments in and payments out, that's what's going to really save you. And so if you've got that all clean, and you should be golden. But if you don't, then you're going to have to air out your dirty laundry and probably show them your bank records once litigation gets rolling. And the key thing to remember is don't use payments on Project X for anything else. So that's not for the pediatrician, that's not for Project Y, that's not for anything. So here's the kicker. You know, proving intent, proving a knowing violation, the courts are not, they don't really want to stick it to you, okay? And so, you know, it takes a lot to get there. But here's a slam dunk way that will get them there every single time, because there's case law on it now, unfortunately for some clients. The surefire way of proof that a GC or a contractor, subcontractor, intended to permanently deprive, to get to the knowing violation, to get to those treble damages, to get to the attorney's fees, is, you guessed it, a prior lawsuit where the general contractor or a subcontractor, if that was the case, was involved with the trust fund claim. So if you've got, if you're ABC general contractor and you're being sued as a general contractor for a trust fund claim, which is rare, but it happens, then if you were involved in prior litigation where you had either been sued as ABC general contractor, or you were suing somebody else as ABC general contractor under the trust fund claim, that's public record. Every single attorney can quickly get that. And that is the proof that you knew about the trust fund, and you knew that if you didn't use the money from Project X for Project X, that you would be violating the trust fund. So slam dunk, game over, treble damages, attorney's fees, all of that good stuff. There are exceptions to the trust fund statute. So here they are, but I'll caution you on these because it's something that you would have to take all the way through trial. There are factual issues to prove that you didn't have to hold the money in trust. And I don't know that you'd want to go to the time and expense to do that. So here they are. You're not required to hold funds in trust if the contractor or subcontractor has a good faith belief that any asserted lien or claim is not valid. So good faith belief, the contractor claims a set-off in good faith or furnishes a performance or payment bond, or the owner executes a written release to the contractor or subcontractor. So, good faith belief. What is a good faith belief? That's a tricky one, but if you, the best case out there that kind of describes that is the Akron Family Dollar Store case. In that particular case, the general contractor had issues with a subcontractor, and the subcontractor wasn't paying folks downstream, and so he was submitting things that weren't really matching up with the payment, with the bid that he gave, and the general contractor asked for more information, and there were a bunch of other red flags that kind of popped up where it looked as if he wasn't going to have enough money to finish the project, and so with that, the court held that the general contractor did have a good faith belief that he was entitled to a set-off, and so didn't punish him and find a trust fund violation in that case. But that's definitely the exception out there. Most of the cases deal with trust fund violations where they're actually found. So that gets us to the question of waiver. Can subcontractors actually waive their rights to assert a trust fund claim? Yes. You can put that in the contract. You can require your downstream subcontractors to release their claims if they'll agree to it. I wouldn't agree to it, and I wouldn't advise any of my clients to agree to it. That is absolutely ridiculous. But if you can get somebody to buy it, okay. The unanswered question here on waiver is whether a subcontractor's waiver of a trust fund prevent recovery by an owner against a general contractor for trust fund claims. Still an unanswered question. And that brings us, all the bad stuff is over, so yay. And we'll just move right on to mechanics liens. So with mechanics liens, I'm just going to hit the high level issues. We were talking about the amount of the lien. It's really, really important for the amount of the lien not to overstate it. So if you have a contract for $150,000 and the property owner, you had your contract with the property owner in this case, stopped you after you had only done $50,000 of the work and didn't pay you for any of it, the only amount that you can lien was the $50,000 of the work that you did. You cannot lien for your full contract amount. You cannot lien for your lost profits. You can't lien for anything other than the value you actually put into the property. And it has to be a reasonable value because they can challenge you on that. So if you're saying that it was $50,000, but 9 out of 10 other contractors would say, no, that was a $10,000 job, and there's only $10,000 of value added to the property, then your lien better be for $10,000. Is there a contract required for mechanics liens? Absolutely not. Not at all. So yeah, don't have to have a contract, and it's for the value, again, that you added to the property. Here's the important thing to remember: the trigger. Trigger to send your notice and file your lien is your last day of work. And I'm going to pause for just a second and take a drink of water, if you'll let me. So the last day of work is important here. A lot of folks think, well, it's, from when I sent my invoice out or when the invoice was due, but you absolutely need to have something in your system. Make sure that your field folks are communicating, it's getting documented in your file when the last day of work was. And so, if you turn this over to an attorney to pursue your mechanics lien, that's the first question that we're going to ask is, when was your last day of work? And your last day of work cannot be punch work or warranty work. You can't make up an excuse to extend your lien deadline by going out there and, tapping in a few more nails, on some siding. So that doesn't work. It's your last day of actual work under your contract or change orders. Your deadline is 4 months for filing your lien, but you have to do things a little bit quicker because you have to give a notice that you're going to file your lien 10 days before you file your lien. So what I like to say is you really need to start this process, even though the deadline is 4 months, you need to start it 90 days after your last work. And that's typically when we help folks out and help them with their liens, is if they still have time on the clock. So you will need to do a notice of intent to lien and a lien, and they're all done in the same package, but you have to wait 10 days after you kind of complete that package and sign off on things before you actually file your lien. So the purpose of it is so that you can give the property owner a chance. You can show them that you're serious because you have your lien right there in the package, and you say, see, here's what it looks like, and I'm going to be filing this if you don't pay me in full within 10 days. And a lot of times you get action on that. So make sure to not put yourself up against the deadline. Another thing that you'll want to watch out for is that on the mechanics lien, this is something that you have to swear to and get notarized. And when you swear to it and get notarized, it's important to not have it be notarized by a family member. I can't tell you how disappointed I was to see that one of my clients on payment applications was getting everything noticed on the payment applications by his wife. Fortunately, it wasn't something that got picked up by the other side. They didn't pay attention to that fact, but it pretty much invalidates everything, and it really could jeopardize the person's notary who's notarizing it. It's a big violation for being a notary. Okay, here's the big one. Absolutely, positively do not ever waive your right in the contract to assert mechanics liens. You're basically, that's another way you're saying, hey, hi there. I'd really like to work for free on your project. Would that be cool with you? And they're going to say, yeah, that'd be great. I'd love for you to work for free. All right, don't do it. Absolutely don't do it. And if you're getting contracts and you don't have time to read them, assign somebody else in your organization to read them. Tell them that, number one, you've got to have attorney's fee provision in there, and don't waive your right to trust fund. Don't waive your right to mechanics liens. Those are big ticket items. Pay if paid. Knock those out. So there's 4 huge big ticket items that you never should have in any contract, and they're pretty easy to spot. But we're happy to help, and we're happy to mark those contracts up for you if you don't want to do it. But don't ever do a job where you haven't read the contract, or you haven't had somebody in your organization read the contract, or you haven't sent it to an attorney, because there's so many GCs out there that have crazy one-sided contracts, and they're going to ask you to pretty much work for free. So just please don't do it. As we touched on earlier, one of the reasons I don't think that Colorado is really favorable for contractors is because of the attorney's fees and costs. They're not recoverable for mechanics liens, but I do have a way around that, and I'll show you in just a second. The other thing that you want to remember is that the foreclosure, if you're going to foreclose on the property, it's 6 months from your last work or the project completion, whichever is the last thing that happens. So if you did the dirt work on a project, it could be a year later before the project was actually done. So you can wait before you file your foreclosure lawsuit, but you don't have to. You can move on with it if you're not getting paid, and that exerts pressure on folks. And typically when we file the foreclosure lawsuit, we're doing that along with a breach of contract claim, an unjust enrichment claim, a trust fund claim. We throw them all in there. We don't just move on the foreclosure claim. But if you don't have an attorney's fee provision in your contract, and an attorney's fee provision in your contract that says that they have to pay for mechanics lien and foreclosure, then you're going to have to probably end up paying out of pocket for your attorney to move forward with foreclosure. And typically that's going to cost around $50,000, if not more. So here's things to watch out for in mechanics liens waivers. So let's say, you're asserting your mechanics lien, or, the GC on the project or the owner said, well, I'm going to pay you, but I need you to sign this mechanics lien waiver if I pay you. So the first thing you want to really think about there and make sure is that first you sign a conditional lien waiver, and that's conditioned upon you getting the payment. After you get the payment, and for your next payment application, you can send an unconditional one for the prior payment that you received, and then give them a conditional one for the second payment that you're about to receive, okay? That's all good, but you don't want to give them a full lien waiver if they haven't paid you. That's a little bit of a problem. But here's what you really have to watch out for, and you need to personally read this, task somebody in your organization with reading this, or send it to a lawyer, because there's tricky stuff that people put in there. And here's the tricky stuff. Contractor hereby releases all mechanics lien rights or claims. That's okay, but it's not conditional. It should be conditional upon getting paid. Here's the problem right here. I don't know if you can see it, but and any and all claims under the contract. So there you go. You just waived all your breach of contract claims for this payment and for every single other payment, for unjust enrichment, under any bond as against any contractor, the project, the owner, the property, and their improvements. You just waived your right to recover anything else on the project, and they're going to make an argument for that. We would counter that and say, well, it was just with respect to this payment application, but this is super dangerous. Cross it out. If you're signing a lien waiver, just cross that out, initial it, and send it back to them. Another dangerous one to watch out for is that you're warranting and representing that you have fully dispersed all prior payments. So if you haven't done that for payments that you have received, don't sign it, because you're swearing to it. And then the last one is pretty much what you have to do anyway for a trust fund. So it's not so bad, but just watch out for it. I want to also draw your attention to the AIA payment application forms. There's something in the small print there. So whenever, and this is just standard in every form. So when you're just filling that out and sending it on to get paid on a project, watch out for this, because if you haven't paid your subcontractors for a prior payment application, you're just swearing to it that you did here, because those payment applications are signed off on by you, and they're notarized. And so don't swear to it if you haven't done it. Here's the magic contract language. And I'm going to just take a second here to tell you my philosophy on contracts. I kind of think it's in my client's best interest most of the time to do a fair and balanced contract, because that's going to save you time and energy, and you don't have to go back and forth negotiating, because time is money, right? You're not going to have to spend money on an attorney to go back and forth on the contract, right? So if it's fair and balanced, then that's probably a better way. But a lot of times you're getting contracts from GCs that are please work for free contracts, and those aren't fair and balanced. If you're pushing contracts down, and you should push contracts down, if you've got subs or material suppliers, and what you're going to put in those contracts is you're going to put a attorney's fee provision for sure, and you're also going to push down anything that you had to take on in from the prime contract or from your contract with the GC, including if there's pay if paid or pay when paid, push that stuff down, and then retainage. If you have retainage held, push it downstream and make sure that you can withhold retainage on other folks too. For my clients, a lot of times I do 2 contracts for them. I do a fair and balanced one, and I also do a one-sided one for them, because there's situations where they know that they're going to get somebody to sign whatever they want, and they want to have the power, if things go wrong, to really kind of put the pressure on them. So just something to think about. So here's magic contract language on attorney's fees for a one-way, one-sided, it really should be a one-sided contract. So here it is. You can copy this down, or you can screenshot it or snip it or whatever. But should a contractor employ an attorney to enforce the provisions hereof to protect its interests in any matter arising out of or related to this project or contract, this could get you attorney's fees for a negligence claim. I have been successful with this language before in getting a court to give me attorney's fees on a negligence claim, because in any matter arising out of or related to this project. It's not a slam dunk, but wouldn't it be nice, right? Because typically negligence claims are claims that you don't get attorneys for, or you don't get attorney's fees for. Contractor should be entitled to recover from customer its attorney's fees and costs and expenses incurred therein, including but not limited to pursuing and foreclosing on a mechanics lien, mediation, administration, appellate, or bankruptcy proceedings. So that's the one-sided one. Here's the magic contract language for the balanced one. Should either party employ an attorney, all the same, the substantially prevailing party shall recover their attorney's fees. And of course, we keep the mechanics lien in there. So in wrapping up today, wanted to remind you that, this is a sword and shield for the trust fund concepts. So I don't want you to get gouged by the trust fund statute, but here are the key takeaways for you. Separate each project in your accounting system. Payments received get paid out immediately. If you get a demand for an accounting, you need to take it seriously. Get an attorney and determine if you have exposure. We didn't talk about this yet, but if you have exposure, you need to stop the bleeding on the other side's attorney's fees and settle that as soon as possible. Well, with that, I've really enjoyed presenting everything to you today. And if you've got any questions, I'm happy to answer them. You can shoot me a little message in the bar, but that's pretty much it. I hope you guys aren't all out at Costco buying a blood supply of Depends, because I've scared you so badly.
Thank you, Danielle. Do we have any questions? I see none. I got to thank you from Mark. So, all right, folks, I think that wraps it up for our contract education session for today. Look forward to seeing you at Network and Happy Hour at 4 o'clock, and back here tomorrow to hear from Jennifer Lang, where she's going to give us a little bit different perspective on insurance and bonding. And top of the list is protecting your assets. So have a good rest of your day, and I'll see you tomorrow here at 2:30. Thanks, Danielle.
Thank you.